Hello, and welcome to the Pregnancy Help Podcast. I'm your host, Lauren Bell. In this follow-up episode, we're joined by Heartbeat President Jor-El Godsey, General Counsel Danielle White, and Vice President of Communications and Marketing, Andrea Trudden, to provide an update on the hearings in California and New York. We'll break down what's happening in the court, reflect on early outcomes, legal implications, and the ongoing question of whether pregnancy help organizations can continue to offer timely and life-affirming help to women in need. Thanks for joining us today, everyone. Andrea, I'll hand it over to you.
Thank you so much, Lauren. This past week has delivered several major legal developments that directly impact pregnancy help organizations. From a unanimous 9-0 Supreme Court decision in First Choice Women's Resource Centers v. Davenport, to ongoing hearings in New York and California over abortion pill reversal, to the Fifth Circuit ruling that paused the mailing of abortion pills only to be temporarily stayed by Justice San Alito just 3 days later. It's been a week. So these cases all point to one central question. Can pregnancy help organizations continue offering compassionate, life-affirming support without being silenced or punished for doing so? These legal battles are not only about policy, they're about whether women can continue receiving real options, real information, and real help in their moment of need. So I am excited to be back with my two colleagues today, Jor-El and Danielle. Thank you so much for being here.
Glad to be here, Andrea. Thanks.
Thanks for having us.
Jor-El, I want to start with you. So walking chronologically through the week, let's start with the Supreme Court's decision in First Choice v. Davenport. Why is this ruling such an important victory for pregnancy help nationwide, and actually to a certain degree worldwide?
Well, that's a great question. And I would say not just pregnancy help organizations, but it's actually a very keenly important ruling for nonprofits everywhere, because effectively the intent of the AG there in New Jersey was to kind of intimidate the pregnancy center by asking for their list of donors. And so there was this big discussion, and there's this path, and I'm not the lawyer. Danielle can help straighten out whatever I say that might be slightly off. But essentially, this is really a state conversation, but it became a federal conversation because it was really a First Amendment question, and it was a protection scenario. And so the ruling, in one sense, the fact that it's 9-0 is amazing. The fact that it basically pushed back on the idea that these powerful AGs, and we know, of course, that there are abortion states with very powerful AGs. Heartbeat knows that especially well. These powerful AGs are able to do things, and sometimes they do things that are actually politically motivated or ideologically motivated, and not necessarily about true law enforcement, which is what an AG is supposed to be about. So for the sake of pregnancy help organizations, this tells a bunch of other potentially aggressive AGs that they should be very careful making these steps. They should not overstep their bounds. And so this was a rebuke, in a sense, by the Supreme Court on this effort to try to do that, and that in fact they can pursue this action. This court case actually goes on. It continues. This was not a full ruling on the merits of it. It really was on a key piece about the action of the AG relative to the donor list. So the good news is that we got a 9-0 decision. How often does that happen? It's kind of amazing that it was 9-0, but that the actual court case now continues, and that tells us something else. But this is key for all of us to remember. And I want to commend Amy and her team. I mean, they received this notice that they were being subpoenaed. This is a long time ago now. This is a couple of years ago, and they've been walking through this path for a good amount of time to really get to this point. In fact, I remember praying that for the fact that SCOTUS would take this up. There were several opportunities for them to do so that they did not take, but they kept it on the docket and then they took it. So this is good news that the Lord gives us an opportunity to be before the Supreme Court of our land with our people, and we're grateful for this win, which does help pregnancy help organizations across the nation. Any one of us who have donors, who are 501c3 boundaries. And that's why I say it's really effective for other nonprofits as well, who might be similarly positioned with an aggressive attorney general who is working on a political path or ideological intimidation than really law enforcement. Because as this was evident, there were no actual complaints to the AG that they could point to for this action, and that just exposed the aggressive nature of it. And I would say that, anytime that our courts speak so strongly in favor of pregnancy help, it really echoes around the world. I've traveled many countries, and I'm always amazed at how much our friends in other countries know about our politics and our systems. And they certainly are aware of Roe versus Wade, and they were excited for that being overturned. And so anything that supports the positive work of pregnancy help really encourages them, even as they operate in different types of governments. They at least are excited about the opportunity that they see here in the U.S. for good footing and really good purchase for the work that we do happening even in the most blue of blue states and abortion states like New Jersey.
Well, and you would think that, knowing that the ACLU even wrote an amicus brief on behalf of this to say, no, you can't just go in and subpoena for donor records of any organization, that would kind of put the attorneys general in their place. However, we've already seen that New Jersey doubled down because, as you noted, this started years ago under a completely different attorney general, Plotkin, and now has changed over to Attorney General Davenport, whereas she doubled down and said, okay, we need to expedite this, and you need to get those subpoenas answered right away. So, Danielle, moving to you, knowing that in New Jersey this is continuing to happen, and then in a way, New York, we're seeing this ongoing legal pressure surrounding speech and subpoenas. How do these connect to the broader question of whether pregnancy centers can freely serve women without government interference?
Yeah, it's a great question. I mean, one of the first things that I want to make sure I say in the wake of First Choice is any pregnancy center that finds itself receiving a subpoena should absolutely reach out to counsel immediately. There was sort of this funny moment in the oral argument when New Jersey was trying to claim that their subpoena was a non-subpoena because, not to get too much into the legal weeds, but they were saying it was non-self-executing. But basically what they were trying to argue was like, oh, no, it's really not a subpoena. And the Supreme Court saw right through that. And one of my favorite lines from the First Choice case was when the justices noted that the value of a sword of Damocles is that it hangs, not that it drops. So it's that fear. It's that fear of what is the AG going to do next? And those of us who are operating in states where the AGs are not friendly to what we are trying to do, we know that, right? We all know that sword of Damocles does seem to hang over us. But it is encouraging to see the Supreme Court jump in and really recognize that just the threat of having such a powerful actor come in and leverage state power, state police power against these nonprofits, the Supreme Court saw right through it. So that's very encouraging. We are continuing, speaking of state AGs, leveraging their police power. Our litigation is ongoing in both New York and California, and I would say more than ongoing, it's really heating up. There's been kind of a litigation in general has a little bit of a hurry up and wait reality of rapidly approaching deadlines and then waiting for many months for the court to decide. And then rapidly approaching deadlines. We're in the hurry up phase right now. So in both New York and California, we had consequential hearings, really important hearings in the last week. And so I can get into what happened in each of those hearings.
Yes, please do. Because the last time we met, it was right before. So like trials had just been issued, and we were like, how's that going to come into play? And so then, since then, New York, and then after a couple of delays and reschedules, California. So yes, please get into how those cases have evolved since we spoke last.
Sure. I'll start with New York, and I'll refer back to our previous podcast for anyone who would like to get caught up on what's happening in New York and what was at issue. We were there on our anti-SLAPP motion. The court heard argument on our anti-SLAPP motion in New York, and the court asked for additional briefing. in part because of that Childs case that you referred to, Andrea. Childs came down shortly before that argument, and it had some pretty serious implications for the case in New York, especially with respect to it, the Supreme Court talking about the medical consensus and how a prevailing medical consensus of a certain time cannot be used to shut down the First Amendment free speech rights of those who don't follow the consensus in that moment. And, in some ways, abortion pill reversal finds itself in that dynamic where there are some medical providers and professionals who believe that abortion pill reversal is not well supported. And then there are others who believe that it's very well supported. And so it's really not appropriate for the courts to come down in this moment and put their thumb on the scale of one side of the debate to shut it down. So the New York court recognized that Childs case has an impact on what's going to happen next and asked for more briefing. So we were encouraged about that. I believe that we're confident that Childs is helpful to us in that case. And remember, this is on an anti-SLAPP motion. And so what that means is we're still at the very beginning stages. We have not proceeded to discovery in that case. And we're hopeful that we never will proceed to discovery, because the very purpose of an anti-SLAPP motion is to cut off that discovery that can be very costly, can also feel a little bit like a sword of Damocles too. So to reference that first resort case. So the briefing is all due into the court. It will be fully briefed, as we say, which means both sides have had the opportunity to submit argument May 20th. So we'll be looking for a decision sometime thereafter in New York from state court.
And so just last week, we were in California. Can you give us any updates as to what comes next in that abortion pill reversal hearing? Again, very similar to what's happening in New York, but a different part of the lawsuit.
Right. Yeah. So in California, currently the trial is scheduled to begin on June 1st. And those dates could still move, but we are running really hard for a June 1st start in preparation for that trial. At the summary judgment hearing, there's a threshold issue in California. And what that means is that there's an issue that, depending on how the judge decides, it impacts the rest of the case and how that case proceeds. And that threshold issue is whether Heartbeat is engaged in commercial speech and Real Options are co-defendant, whether we are engaged in commercial speech when we talk to women about APR. It's curious to think that when you talk to women about APR and you don't charge them anything, that you would be engaged in commercial speech. But that's the argument that's being leveled. And the AG has taken the position that our speech is commercial because we're fundraising. That's a position that I think is even further weakened by the first resort case that just came out. So there is this first question of, is this commercial speech? And it matters a lot. It really matters a lot what the court decides about the commercial speech question, because the level of First Amendment protection that our speech receives is directly dependent on whether this is commercial speech or non-commercial speech. And the AG has all but admitted that he cannot succeed if this is non-commercial speech. So that's not to say that there's no protection for commercial speech. There still is good First Amendment protection for commercial speech. It's just a different level and a different analysis. And so there was a lot of discussion about that at our summary judgment hearing, but that's a little bit of like legal nerdery. I think what's a little bit more interesting for our audience perhaps is the AG took the strange position that the harm, so they have a tough fact in the case. And that fact is that they can't produce a single woman who has complained about being harmed by abortion pill reversal. That's quite inconvenient for them. California is a large state, and APR has been going on there for more than a decade. So it's hard to imagine that women are being tremendously harmed by this speech when not a single person has materialized to actually complain about it. And we pointed that out. Our attorneys pointed that out in court. And the response from the AG was that, look, we don't have to wait for someone to be harmed. We're concerned about the harm. And in trying to describe that harm, they pointed to a deposition of one of our APR moms. We have 7 APR moms who have provided depositions in the case and told their stories about abortion pill reversal and the babies that they have following receiving that treatment. And the part of the deposition that they decided to highlight was when the women expressed hope. The women expressed hope when they heard our message. And to the AG, that was problematic. Now, they're framing it as false hope. That's an odd position when the women who were talking about the hope they experienced, they're holding their babies now.
And they were on our side of this case.
Right. Yes. So Peter Breen, who was arguing for us, had a wonderful line where, he said, Your Honor, even if, and I'm paraphrasing, of course, but like, even if these women were deceived, which of course we take the position that they were not, they're the happiest deceived people in the world because they're holding their babies. And that's why they've put their name to declarations and they've sat for depositions so that they can tell their story about abortion pill reversal and the children that they get to love after receiving that treatment.
Yeah, that was definitely a highlight as we are all surrounded over computers watching the hearing go, and we're all just kind of, they just said that a woman getting hope was deceived. And it was just so bizarre. And I was so proud of Peter in that moment because that is just a natural wit that comes out. But he's so true. It was such a good line because, again, these 7 women were on behalf of abortion pill reversal and grateful that they had the option that the state of California is trying to take away. Again, not the process, but knowing about it and talking about it. And I always go back to the fact that if it was something that was so dangerous and they were so concerned, why would they not go after the protocol, but rather the knowledge of it? And it's because it is just progesterone. And they know that it is a safe and effective way that may, and we specifically say that, may help reverse the effects of the abortion pill. So, and I'm glad you noted about no woman in California has made this complaint or said that they were harmed. Again, no woman in New Jersey has come out and said that they were harmed. So these AGs are putting these claims out there with no women behind any of it. And it is quite fascinating how far they will go in order to push this agenda and to try to silence hope. So, before I shift gears, is there anything further in regard to California or New York? Because we have a whole other Supreme Court piece to talk about.
Just a quick note to our listeners to please do keep us in your prayers over the next few weeks. Having a trial of this level is a huge undertaking, and I'm just so encouraged to see the litigation team really getting after it. They're excited for our day in court and our opportunity to defend our First Amendment rights, and they're working around the clock. So please be in prayer for them. Pray for wisdom from our judge. And just keep us in mind over the next few weeks and in your prayers.
Yeah, that would be excellent. Mostly because unlike on television, the court doesn't wrap up in a half an hour, or a movie where it wraps up in 2 hours. Like, it's actually going to take weeks, that we're told. It may take weeks, kind of depending upon how things go. So that's a lot of energy and effort for our legal team, certainly our team that will be on the ground. And so continue to pray that the Lord intervenes and brings justice, that the judge acts in righteousness. And then we, of course, will hope so that the Lord will allow us to prevail in all of this. We're confident. We're confident in our facts. We're confident in the truth that we know. We're confident in the successes. We just want to make sure that the system is not allowing those that have a bias against us to really win the day.
Very good. So just to quickly recap the past few weeks. So we last talked before April 15th, because April 15th was the day that Heartbeat was originally in court cases both in New York and California. And then we found out on April 14th, while 2 of our colleagues were on their way to California, that the case had been rescheduled for the 17th. That then was rescheduled again for the 29th. So we had New York on April 15th, and then on April 29th, as we are preparing for California case, oh, the first choice decision comes out. So that was a very fun moment to then be able to celebrate with our affiliates and really get the word out and just take in that moment. Then getting right back into, okay, now let's see what's happening in California. And then 2 days later, on May 1st, after 5 p.m., of course, because Friday nights are the best time for courts to drop decisions, the Fifth Circuit made a decision that ultimately temporarily blocked mailing of mifepristone. The next day, Danco and Gen Biopro, both manufacturers of the abortion pill, appealed. And then on Monday, I'm looking at my calendar, May 4th, that's when Justice Alito issued an administrative stay. That's going to hold us till the 11th. So there's been a lot of, I keep saying ping pong, back and forth. And so, Jor-El, I'm going to go to you first, kind of to get an understanding of what this moment means. And then, Danielle, I'd like to pivot to you to get the legal aspect of, like, what does the stay mean? So starting with you, Jor-El.
Yeah, well, this has been a ruling that was a long time in the coming as far as Alliance Defending Freedom has been in this battle. You know, it was sparked by a young woman named Rosalie who was pressured into taking an abortion pill. And it was really her case that said, look, if you had had in-person visitation, I could have avoided this having to take this action that I was forced to by my boyfriend in order to abort my child. So that was really the compelling case that went before the courts, was then before a 3-judge panel of the Fifth Circuit. They voted unanimously to take this step because they tied several things together that really said, you know what, the state of Louisiana should have the ability to protect its own citizens, should have that opportunity, and then declared, yep, you cannot do what you're doing right now, which is mail abortion pills into our state. By the way, this is where some other things start to happen. They really begin to identify the personhood of that child. Several pieces are in play in this judicial action that's happening at the Fifth Circuit, which could echo into the response of SCOTUS. But all of these things are good things in a sense, even though it feels like a ping pong effect, it actually puts these terms, it puts these concepts in play into our legal system at the highest level. You know, no longer, I mean, forever we used to be so aggravated that the courts found standing for Planned Parenthood in the abortion industry for virtually anything and everything that remotely touched on the issue of abortion. They just automatically agreed that Planned Parenthood, because they provided abortions, should have standing. Well, now we're seeing the truth of that and the reality of what happens on the other side, when what the standing really should be is for the personhood of the child, of the baby, for the positive protection of the mother, who is in this instance was forced and coerced. And as you guys both know, we've seen only an increase in the Abortion Pill Rescue Network and in research that we've seen, only an increase in forced and coerced abortions, even those that have been abortion pill poisoning that we know is now happening in multiple states. Like the fact that the Fifth Circuit, so the very highest appellate court next to SCOTUS, made such a strong ruling is a positive step by itself, hands down. Yay, right? However, we have the fact we do have SCOTUS, and we do have this dynamic where, guess what? We've been doing this for a long time, and no other courts have really seriously been able to take this on or been willing to make such strong statements. But now we have these strong statements. It'll be very curious to see how SCOTUS speaks to this. Of course, it's also telling that the primary people opposing this were manufacturers of abortion pills, who are among those that profit from abortions, profit from forced and coerced abortions, I might add. So these are heady conversations that are now happening, and at least it's moving in our direction. Whether SCOTUS jumps in and does it now or not is certainly a question that I'm sure Danielle knows the exact answer of what's going to happen here in the next few days. But regardless of what does, the fact that we're having these conversations at this level is a good thing. And so pregnancy help organizations really need to be aware of what's happening. They need to be mindful. They need to leverage the moment, because what is being said in these court cases, court rulings, and in these conversations very much reflects the reality of what every pregnancy help center knows is happening with the women that they serve. They're being pressured. They're being coerced. They're being forced. Their choice is being taken away. And so that's exactly what these conversations are about. And the fact that they're happening at such a high level is good for us, and it's good for them to echo to their community, to their supporters, to everybody, to the churches. We should be talking about this to everyone. It's a good thing. It really kind of gives us a moment to really speak strongly. And so don't hesitate. You should be crafting your articles right now. You should be writing your letters, your emails. You should be encouraging, hey, look at this, sending the information out of ADF and their press release, sending the things that Thomas More Society is producing about what's happening. And there are amazing things going on that support what you do, that show the strength and power of the service, the compassionate service that you provide. And it's high time that these kind of conversations and these kind of rulings have come from our courts.
And Danielle, are you able to expand a little bit as to like the procedural elements of what we should be looking for next?
Yeah, so I'll just note that the stay that the Supreme Court issued is just an administrative stay. It's designed to try to maintain the status quo while the court takes a little bit more time to do some analysis and write an opinion. My understanding is that we could see an opinion anytime now. The stay, I believe, is extended until Monday, the 11th.
The 11th.
So
as if our week hasn't been busy enough already.
Yeah. So it's just an administrative stay. Nothing. I wouldn't read anything into it, or one way or the other. Pretty routine, I would say.
Yeah. So at this time, the abortion pill still can be mailed because of this stay. So, and then if they come back and find in favor of the Fifth Circuit, and say that their ruling is correct, then in theory, then mailing of abortion pills can be halted. Now, the tricky part of that is that we did get a preview into how people will respond. And so we already saw pro-abortion advocates and commentators throughout there. Abortion is still able to be accessed through misoprostol only means, which I still question that because the mailing would still have to happen in theory. But they're already trying or showing their hand as to what their next step is. And they're also throwing out strategic elements that may include some escalation, so marches and things. So how should our pregnancy help organizations be preparing in case a decision comes down, similar to Dobbs, that pro-abortion activists and I need a better term than activists for just angry people looking for reasons to throw things, may respond, knowing what we've known over the past couple of years. How can we learn and apply some of that knowledge from Dobbs for what may come to fruition again if another decision comes down that is on the pro-life side?
Well, we've already seen some hints that this is what they're preparing. Now we don't have necessarily intelligence on, not that any of this is intelligent, by the way, but we don't have any intel that these things are happening, are definitively planned. We just have kind of the hints, some of the same things that we saw 5 years or 4 years ago. We are now seeing them doing, like they're sending out surveys. They're talking about a day of rage. They're talking about certain things that echoes what happened when Dobbs came down, even during the leak. If you recall, like this was a big deal. And I know it was a big discussion about security at centers. We had vandalism, everything from things that were seemingly benign, chalk on sidewalks, although frankly some of the messages that the chalk carried were actually threatening messages, which are not benign at all. Then we saw spray paint. We saw all kinds of things. We even saw vandalism in the form of broken glass, broken windows. And then the worst part of that is we saw actual firebombing of several locations, including the center, by the way, I used to run back in Colorado, was a victim of that. took them offline for several months before restoring and renewing that property to be able to serve clients again. So these are things that we began to see happen, and frankly, it caught us kind of flat-footed because at the end of the day, we're just trying to help women, make a choice, right? Which I thought that's what they wanted. They were proponents of choice. But pregnancy help organizations and churches who are strongly pro-life represent kind of soft targets for such things. Now, we hope that our DOJ will be more inclined, the FBI will be more inclined, which, by the way, something we learned in recent weeks was that, yes, there was a weaponization of the DOJ against pro-lifers. And I can tell you from having reviewed those documents, particularly the parts that were about the actions that we just talked about, the vandalism and the violence perpetrated against pregnancy help centers, we saw something on the reverse, which was whenever there was an action against an abortion clinic, the first phone call, it seemed like, or the first call that was made by the abortion industry was not to the sheriff or not to the chief of police, not even to 911. It was to the FBI. And I even asked, I said, well, was this something that should be a path that we should be mindful of? And I was told absolutely, because as long as the FACE Act is in play and it's in question, it's being, there are several calls for its repeal or replacement. But as long as the FACE Act is in play, then the one thing that we know is that pregnancy centers are reproductive health facilities according to the FACE Act, and so that makes it a federal issue. So the minute that you see someone outside who you're concerned about, or the minute you have any action or activity that is of the vandalism or violent nature, you should, yes, reach your local facilities, but immediately call the FBI because they need to be advised. Because one of the challenges why there weren't more enforcement against such things that the FBI raised was that they were not contacted soon enough. And so we need to, this is a weird place for us to be. Like we don't want to have to contact any law enforcement. There should be no need. But our opposition is putting themselves in a place where that might be what we need to be ready to do. So we need to have that information on hand. I would even put it into your cell phone so that you can dial it instantly. The local FBI office, go online, figure out who it is, just put it in your phone for that moment that we hope never comes, but that you have to reach out. You want to be able to act quickly. And if you've installed your security system and you've kind of gotten, it's not been activated as many times as it was when you first installed it and you first had to hey, get back to it. Tighten up, particularly in this season around this decision and around whatever may come next, because depending upon, as Danielle said, we're not sure what this means. That we can't read into it what the fact that it was stayed doesn't tell us one thing or another, but we have some very powerful opportunity and possibilities, and the other side is gearing up for it. And we've already seen that one of the ways they act when they get bad news is throw tantrums, and they throw it at us, and they throw it in a violent way.
And the good news is, after the Dobbs decision happened and we started to see this, we pulled together a lot of resources. So we will link to that in the show notes to get back into those resources, because it does have some really good content that you should review, not only yourself, but I would suggest with your team, so that anybody who is arriving and may be the first to the scene knows what protocol to go for. Take pictures. You want to have all of it documented. You want to have that phone call with the FBI because, as you noted, Jor-El, the other side was doing this where they were documenting every single time a sidewalk advocate would be outside, to where we don't want to be seen as nuisances, but we do want to record and document things. So that is something that we will put in the show notes just for your review, and be certain that you are as ready as possible. Favorite phrase in my family is better to have and not need than to need and not have. And so our job and our goal is to equip you with those resources to have on hand and be ready within your centers.
That's absolutely true, Andrea. And at the same time, we should also remember, we carry the love of Christ, we carry the compassion of the cross in our hearts. And for those who are opposed against us, the scripture is clear. We're to pray for them. And so there's been, there's this longstanding kind of discussion in our movement about how to deal with protesters on the sidewalk, those who came to voice their opinion. And, I've heard many great stories about, yeah, we brought them cookies, we brought them, muffins or donuts, and they really didn't want anything to do with us because they were just angry and mad. Like, but we showed them love, and we still need to do that. So it's kind of a tricky balance, right? Because as we can see, and we were talking just before the podcast, the idea, like what we just saw at the attempted assassination attempt, in the White House Correspondents' Dinner. What we saw was someone who looked normal, who you wouldn't necessarily identify, and what you wouldn't walk by on the street and think, wow, that person, is really angry, an angry activist. But they are, and this person was. And while that's not what we would ever expect, or certainly hopefully ever have to be concerned about that level of violence. But it's the idea that, look, just because someone outside looks like they're just standing and watching what's happening, you just never know. So be on guard, have your discernment meter up. But as Andrea said, be prepared, document everything, work in coordination. This is a good time to review your policies that help you kind of avoid those things, that help you just reinforce good practices for the protection of you and of your center and of any and all of your staff members, and of course of the mission that you've been called to fulfill.
That is a great closing of the questions, but I am going to throw one more at you that may be a little unfair based upon all the different things that we've seen in the past week. But Jor-El, in your mind, from what we've witnessed, what was the most significant takeaway just this, like with everything that we've been talking about recently with these court cases? Which was the most significant takeaway for pregnancy centers?
Well, probably the most significant one is that God is watching out for us. We have felt on the short end of the stick for many, many years, and some things have changed. And part of that is at the court, part of that is in other places. It's the strength of our folks that are leading the way in life states. But pregnancy help is the kind of the anchor. It's the essential power of really the pro-life movement. And so while we're grateful for all of the things that are happening elsewhere, the reason that we are the target of so many things is because we have been effective. The reason that we are finding a level of ascendancy. I mean, good grief, we we had our first SCOTUS win in 2018, and here we are again. It's like wow, these are big things. They're good things, and there's a reason that these are big things, because it's so important to help women every single day to have a choice other than abortion. It's critical. It's the thing that I think God is elevating us and kind of escalating our work in a way that is drawing the kind of attention we don't want, but is also establishing the kind of attention that we need in order to preserve and protect pregnancy help going forward.
So Danielle, same question to you. In the last week and all the things that have been going on, what's been the most significant takeaway for pregnancy centers from your perspective?
I've been reflecting a lot on, and this is maybe a little bit of a roundabout way to answer your question, but I've been reflecting a lot about trust in the Lord and in His timing. It's so interesting to watch how the timing of even just the decisions at the Supreme Court, they didn't come a moment too soon, Lord. Like we could have had that a little bit sooner and that would have been okay. But, sometimes maybe the Lord has a flair for the dramatic, but he has a plan in it all. And sometimes I'll be going to Him in prayer and asking for specific things, and then kind of say like, asterisk, you have a better plan than me. So if there's a better way to come about this, like, go ahead and do that. But I think that the takeaway for me has really been that the Lord is on our side.
Thy will be done is always I am an impatient person in many ways, but I will always try to slip that in. It's like, all right, if I know you know better. So depending upon the Lord, I think that is very true. We've been watching the momentum. We've been watching things come into play, and we need to continue to be patient and to have that trust. And I think that that's a really good reminder for not only us on this board, but then of course the movement. So I think that it is a great way to kind of close and to keep in mind. We do want continued prayers, of course, for each of these cases as they move forward. We are continuing to move forward, and that is a very positive thing, as well as just the different situations going on with the pregnancy help organizations and for the protection and safety as we navigate the next season, the next chapter. So, any final thoughts before we close out today?
Well, I really appreciate you guys kind of calling out patience and that the Lord is at work. I think in some parallels, we have to realize some of the other moral imperatives of our day, and I look specifically at our country as far as slavery. It's like that, what it took for us to overcome that was major, and it didn't just take a civil war, which was really major. It took actually several decades beyond that to get to even a better place. And so partly like let's have patience with the process, but usually quick wins create also quick losses, and we see that every election, every presidential seasons, and when the executive orders start flying, if it's on our side, they're flying in our favor. When it's not on our side, they're flying against us. But these kind of wins that are happening in our courts also create, I think, wins in our communities and certainly wins in our culture that we need to maintain, and that really help us become more and more that culture of life that we know needs to happen in order to truly make abortion unthinkable in our land.
Amen. Well, Jor-El and Danielle, thank you both for joining me today and helping break down these important legal developments. As we've discussed, the cases are about far more than courtrooms. They're about protecting the ability of pregnancy centers to speak truth, to serve women, and offer life-affirming care without government intimidation or interference. So while we are still moving forward in both California and New York, we do remain hopeful and encouraged, as Jor-El was just saying, by everything that we have been witnessing. So we ask listeners today to continue praying for wisdom for the courts, protection for the pregnancy help organizations around the world, and most importantly, for the women and families directly impacted by these decisions every single day. So I would like to encourage you all to check out the show notes for these important links in regard to the court cases, as well as the center defense tools that Heartbeat International has prepared for y'all. And then please like and subscribe the Pregnancy Help Podcast. And we will probably be back in a few weeks with new updates. As we are just watching things move very swiftly, we will keep you up to date as to how this may impact you and your organization. So thank you so much, and thanks for listening to the Pregnancy Help Podcast.